After a DUI, a law enforcement officer may take your driver's license, issue you a 1205 form, and initiate a license suspension proceeding in the administrative courts. This can put you in a tough spot where you have to determine whether to install an ignition interlock device or request an ALS hearing, an administrative license suspension hearing in the administrative courts. It is a difficult decision. If you refuse the state-administered chemical test after being read implied consent, then what you are facing is a 12-month license suspension. That can be avoided in a couple of ways with an ignition interlock device, by winning the ALS hearing, or sometimes by negotiating with law enforcement. The ALS hearings are difficult to win in many cases. So if you elect to do the ALS hearing, you may have a decision to make, because oftentimes if you lose the hearing, which may put you in the best position to fight the DUI, you're going to be looking at no driver's license for 12 months. Officers have a lot of leverage in this scenario, and many times the officers will say, hey, I will agree to withdraw this license suspension if your client will plead guilty to DUI. So in the context of a refusal to participate in the state-administered test, coupled with an ALS hearing requested, as opposed to an ignition interlock device, the law enforcement officer has an extreme amount of leverage over the suspected drunk driver, and it is something that you should talk to your lawyer about as you battle your DUI.